Hi, in this presentation, we will discuss about patent infringement litigation defenses. So, whenever a person receives a notice for patent infringement, he has various defenses. Defense number one is he can challenge the validity of patent on different ground. Second defense is he can assert that patent is not infringed by his product. His product is not covered by patent claims. Third defense is he can say that patent is not enforceable because patent has been procured by fraud or inequitable conduct by patentee during patent prosecution in patent office. Next defense is equitable defenses, which includes Laches and Estoppel. Laches applies when there is a huge delay in bringing the infringement suit. Estoppel applies when patentee or patent holder misleading behavior or conduct led to infer by the infringer that patentee will not file infringement suit against him. We'll discuss all these defenses in detail in coming slides. Other defenses given below are basically the exceptions to patent infringement. First is experimental use exception. Under experimental use exception, it is allowed to use the patented product for development of information and submission of such information to regulatory authorities for generic approval. So this exception is very important for generic pharma companies. Generic pharma companies can use the patented branded product for generation of bioequivalence data and other data for submission to FDA for generic approval. Next is prior use. One can assert that he is using his product for a long time even before filing date of patent application. If you can prove it, it is a very good defense. And in case of US, he can prove that he is using his product even before 12 months prior to filing of patent application in US. Next is patent exhaustion on first sale. Reselling of an item that was legally purchased from patentee or licensee is allowed. The patent rights exhausts in a product upon its first sale and it can be resold any number of times after first legal sale from patentee or the licensee. Next is a repair use exception. Whenever one has purchased a patented product legally, then he has the right to repair that product during the product's life. Now coming to the first defense, patent validity challenge ground. Patent validity can be challenged on different grounds as given in this slide. One can assert that invention does not have utility. Next is no novelty ground. One can say that invention is not new or novel and it is anticipated by prior art. Next ground for challenging the validity of patent is obviousness or no inventiveness. One can assert that invention is obvious to one of ordinary skill in the art and it does not involve inventive step. Next ground for challenging validity is not enough disclosure in specification. There is incomplete written description. Examples given are not enough to explain the invention. There is no enablement of disclosure. Invention is not well explained or described, and it does not enable person of ordinary skill in the art to practice the invention without undue experimentation. Next ground for challenging validity is best mode is not disclosed in the invention. Next ground for challenging validity is claim are indefinite. They are not clear. They are not precise. Claims are ambiguous. The claim language is ambiguous. So these are all grounds based on the basis of which the validity of patent can be challenged. Now, coming to this, when the infringer is challenging the validity of patent during patent infringement litigation, there is a section 282 notice requirement. Invalidity defense by infringer that depends on prior art such as anticipation and obviousness can be asserted only on special notice to patentee, and statute requires notice in pleading or otherwise in writing at least 30 days before trial start. What counts is notice of intent to challenge the validity of patent. Merely mentioning reference in pre-trial papers and neglecting to indicate that it will be used at trial normally does not constitute adequate notice. Now coming to second ground for second defense in the patent litigation infringement litigation cases, patent is not enforceable because of inequitable conduct of patentee during patent prosecution, and the patent has been procured by fraud. So this defense in patent litigation suit is that patent is not enforceable. So inequitable conduct is an offense committed most commonly by intentional failure to submit the material reference by patentee to examiner, and patentee has misrepresented the material facts to the examiner, and patentee has made false or misleading statements to the examiner, and all these were coupled with intent to deceive the examiner in order to obtain the patent. So if the all these elements are proved, then patent will not be enforceable because of inequitable conduct of patentee during patent prosecution. Patent procured by fraud or inequitable conduct will make patent unenforceable permanently. So next defense in patent litigation, infringement litigation, equitable defenses. So equitable defenses in case of patent litigation, patent infringement litigation. Equitable defenses to claim of patent infringement recognizable under section 282 are Laches and Estoppels. We'll discuss these in coming slides. So Laches defense in infringement litigation. If there was unreasonable and inexcusable delay in bringing infringement suit, then Laches may apply. Under Laches defense court, under Laches defense, court confirm the following basic views. A presumption of Laches arise when patentee delayed in bringing suit for more than 6 years from date patentee knew of infringement or should have known of infringing activity. Two elements that underlie Laches' defense are patentee delay in bringing suit was unreasonable and inexcusable, and infringer suffered material prejudice attributable to delay in suit. Material prejudice may be in form of economic and evidentiary prejudice. Economic prejudice may be in terms of damages or loss based on investment and expansion of a business during Laches period. Evidentiary prejudice includes foggy memories, death of important witnesses, loss of documents during Laches period, and these witnesses and documents are important in infringement suits. So, if these are lost because of Laches, because of late bringing of infringement suit, then there is a loss to the infringer. Where defense is for Laches is where defense for Laches is established, then patentee claim to damage for infringement prior to suit during Laches period may be barred. Patentee will not be able to recover the damages for the infringement during Laches period. If the patentee plaintiff has an established sequential licensing and litigation pattern, then defendant position is worsened. Suppose in the past the patentee has licensed his invention to many companies and he has sued all the infringers, then he has strongly enforced his patent rights, and in that case the infringer position will be very weak. Court recognized that delay in bringing infringement suit may be excused by fact that patentee had no means of learning of infringement, or if the infringer deliberately concealed its infringing activity. If this is proved, then Laches will not apply. Period of delay does not begin until patent issues. The recognized excuses by court for delay in bringing infringement suit by patentee are other litigation in which patentee was busy, if there was delay by USPTO in USPTO proceedings, there was long negotiation with the accused infringer and infringer has not agreed because of poverty and illness of patentee, because of war situation in the country, extent of infringement, disputes over title of patent. These are various excuses which have been recognized by court for delay in bringing the infringement suit. Now coming to equitable estoppel as defense for infringer. Court has outlined three elements of estoppel for patent infringement litigations. Patentee, first element is patentee through misleading conduct led infringer reasonably to infer that patentee does not intend to enforce its patent right against the infringer. And this misleading conduct or behavior may be some specific statement in the past. He has given statement that he will not file the infringement case. It's some actions or inactions or silence where there was obligation to speak, and this first element requires that infringer should be aware of the patent and infringer be able to infer that patentee knows of his infringing activity. Second element to prove estoppel is the infringer relied on the patentee's above misleading behavior or conduct. And Third element is due to its reliance on misleading behavior or conduct, the infringer will be materially prejudiced or harmed if patent is allowed to proceed with its claim. So three elements to prove estoppel is: first is patentee misleading behavior or conduct, that he will not file case against infringer. Second element, the infringer has relied on this misleading conduct or behavior, and because of reliance on this misleading behavior of patentee, infringer will be materially harmed. The equitable estoppel, when established, it entirely bars the assertion of patent claim for infringement. In case of Laches, it bars only damages for the Laches period. But in case of estoppel, when it is proved, it will bar the assertion of patent claims completely for the infringement against that infringer. Now, coming to declaratory judgment by infringer. Whenever somebody fears the threat of infringement case by patentee, when there is a potential for patent infringement sued by patentee, the defendant can seek a declaratory judgment from court that patent has not been infringed by his product, or that patent is invalid, or that patent is unenforceable because of reason that the patent has been procured by fraud or inequitable conduct. Such a judgment can permit the potential defendant to have control over timing and forum of suit. However, the subject matter jurisdiction requires that a case or controversy exists between the parties. Controversy about patent infringement and validation exists. So ultimately, court will decide whether patent is infringed or not infringed, whether it is valid or not valid, whether it is enforceable or not enforceable. So that's all in this presentation. Thank you very much.